respectfully reserve 5 minutes for rebuttal.
Yes, sir. I'll keep track of it, I hope.
Yeah, my name is Andrew Crawford. I am here on behalf of Keandra Walker. This case comes to this court after an appeal from a denial of a motion for downward departure in Pinellas County. The particular ground for the appeal, which is the most relevant for this appeal, is the denial of downward departure based on a three-part analysis of mental health disease or defect that requires specialized treatment and that the defendant is amenable.
Well, let me ask you a question, because
Yes, sir.
I haven't been a trial judge. I dealt with downward departures on a regular basis. Do you have a case that says the judge is required to give a downward departure if you meet the statutory grounds for downward departure?
No, Judge Valenti, no
So
such.
what is your argument that the judge abused his discretion, saying it's not a good fit for this person?
Well, Your Honor, in candor to the court, I looked for a case specifically on that exact issue. Because
It's technically the opposite of what you're arguing, isn't it? Do we have to go on bond to recede from our previous case law to get where you want us to be?
You do not. There's not a case directly on point that I could find in Florida, like the Attorney General's office noted in their answer brief, that addresses a situation where an appellate court has found that a trial judge has abused their discretion on the second part of the analysis. But the
It
focus.
would open up a whole can of worms, wouldn't it? If every time somebody met the criteria for one of the downward departures, the judge had to grant the downward departure?
Correct, but we'd have to get there first, Judge Black. Really the question, the issue on appeal is whether or not the judge misapprehended his ability to depart from the sentencing guidelines and whether.
You're dealing with a pretty good judge, an experienced judge. You're not dealing with someone who didn't know the law. And is the main grievance here the sentence, or is that irrelevant to the downward departure argument?
Well, as an appellant, we cannot necessarily appeal a legally imposed sentence unless there's some type.
It's a legal sentence, right?
It's a legal sentence. It's not above the, it's not
And
above
there
the
was no
statutory
plea
max.
bargain, right?
There was no plea bargain. It was an open plea to the court. However, this court does have jurisdiction to review and has made it.
No, that's what we're doing. I'm just trying to get on the same page with you.
Understood. In this particular case, the judge determined that he did not have a sufficient basis to depart, specifically that the defense in this case did not prove an amenability to treatment by the preponderance of the evidence in this case. That is the basis for the error on appeal. I would submit to the court that the defense did. There's, as the court knows, there's 3 steps.
Did the judge rule on the alternative?
The judge did, and said it was not, that the defense did not prove by the preponderance of the evidence an amenability to treatment. In this particular case.
That's a matter of opinion.
It's,
Well, if his opinion is you didn't prove your case, is that good enough? Or if his opinion is wrong as a matter of law, is that good enough to get a reversal?
well, there's a 2-step standard of review, whether or not he applied the correct law,
Okay.
which he did in this particular case. And the second question is whether or not there was competent substantial evidence to support his rule.
Well, even the witness testified that given the nature of the mental impairment, if you will, was not easily amenable to treatment. So there's some doubt as to whether amenable to treatment was satisfied. There's no question about the test validity as it relates to possible malingering. Isn't that enough to support the judge's decision that I should not depart?
No,
Depart.
no. And in this particular case, Dr. Eiler, it's on page 250 to about 256 of the record in this particular case. Dr. Eiler, who was the defense expert, was opining as to borderline personality disorders. He said generally they're difficult to treat and they're generally not amenable to treatment. But in this particular case, the defendant specifically had sought out courses while she was incarcerated in Pinellas County Jail. And he made a finding based upon that it seemed like she was reaching out for help and trying to get the help that she needed. And if she was able to do that, his opinion was with dialectical behavioral therapy, which is DBT, plus a medication regimen, that within 6 to 12 months, she would have been amenable to treatment. Judge LaRose, he was the expert was opining as it related to borderline personalities in general, not specifically the defendant in this case, and that's the crucial distinction between the two. But it's pretty clear that based on the testimony, there was a mental disease or defect, which was borderline personality disorder. There was a need for specialized treatment, which was generally accepted within the psychological community, which is dialectical behavioral therapy, with a medication regimen as well. The question was whether or not the defendant in this case, the appellant, was amenable to that treatment. And again, on page 253 to 256 of the record, and again on page 262, because she had completed certain courses while incarcerated at the Pinellas County Jail, that was indicative of someone trying to participate in treatment.
That she answers the question, she may have reached out, it does not go to whether or not, in fact, she's amenable to successful treatment.
Point of fact, Judge LaRose, it does, because what the expert opined was that, generally speaking, a person diagnosed with borderline personality disorder is generally difficult to treat. Whether or not they're amenable to treatment varies based on person to person. In this particular case, when questioned about her amenability to treatment by a defense counsel as well as the prosecutor, she was, in his opinion, amenable to treatment because she was reaching out to better herself. Now, I understand amenable to treatment, whether or not she was willing to do that. The amenability to treatment is whether or not, based on her condition, that would have been improved. And that was precisely what Dr. Eiler's testimony was, that dialectical behavioral therapy within 6 to 12 months can improve someone who is diagnosed with borderline personality disorder, which is what she was diagnosed with.
Even if you're correct on that point, the judge still has discretion to decide whether to depart.
Absolutely.
And unfortunately for your client, she engaged in this behavior, bonded out, and returned almost immediately to this illegal behavior. And perhaps that did not sit well with the judge's thinking of how to deal with her.
It is true that she did violate the conditions of her bond by picking up a new felony while she was out on bond. In my review of the record, he decided that the trial judge in this particular case decided to not exercise his discretion, but he also made a note that there was not the specific proof requirements met in terms of amenability to treatment. He did exercise his discretion. That may have been his thinking, but in ruling, he specifically made a finding that there was no amenability to treatment when we would submit that there was. In addition, he said even if there was, he said he would not have departed. It could have been because, yes, she did reoffend while she was on bond. But again, I would submit to the court that that was an abuse of discretion. I'm going to be asking the court to
The
reverse.
plea was to all the pending charges, even the ones that were committed while she was out on bond.
Correct.
So what are you asking us to do, to reverse the judge's decision that there was no lawful basis for downward departure and to then give a different sentence, or simply reverse it, send it back for the Part 2 analysis of the downward departure issue?
Reverse and resend it back down for the analysis of the second
If
part.
we think the record supports the judge's sentence that there was no lawful basis for downward departure and or it wasn't a good fit for this defendant, it's a PCA. Otherwise, we'd have to send it back to the Part 2 and have the judge dot the i's and cross the t's, so to speak.
Exactly right, Your Honor.
Okay, I mean, I want to make sure that's what you're asking.
That's exactly what
Well, sometimes I've heard people make the argument, we want the 29 months minimum. But apparently, the judge gave way more than the state even asked for.
The judge gave about 3 times what the state had asked for. And I would love to be able to make that argument. Unfortunately, I can't by the case law.
Appreciate your honesty. You get points for that.
Okay. But again, I would submit that the court's factual findings are not supported by competent substantial evidence as it relates to that ground for departure. Additionally, as to the second issue, while the case was pending, at least the first case was pending.
You switching to the restitution argument?
Yes, I am. Unless there's any further questions.
No, I don't have any other questions, but the restitution argument is a bit peculiar. Normally, you'd have someone like the state say, we need restitution, or the victims would come to court and say, we need restitution. Did anyone speak up in favor of restitution?
In terms of a departure ground, no. The victims in this particular case said, some said they wanted the appellant to get therapy. Some said they would forego the restitution if she did more jail time. I'm not speaking as to the ground for departure. I'm talking about restitution as it relates to what she paid.
Did your client ever pay the additional restitution that he said, oh, I can give another X amount of dollars if I get this better sentence? Was that like on the table?
It's alluded to within the record on appeal that never materialized. What I was speaking to, Judge Flante, was actually ground two,
Okay.
as it relates to the liens that
There's
were.
no case that supports your position on that ground, is there?
There's not cases specifically, but there's a very clear statute that a victim in a criminal case awarded restitution cannot double dip. There's definitely an offset. The unique fact in this particular case, and I couldn't find any cases directly on issue, Judge LaRose, was the 18 months while the case was pending, there was $800 a month that was placed in the registry of the clerk that was ultimately dispersed. And the grounds for the 3800 motion was that despite all the monies paid toward a restitution, the lien that was issued by the court was not reduced by the amount that the defendant had paid during the course of the proceedings.
The judge did indicate that she, of course, is going to get credit for any payment made.
During the 3800 hearing, yes, the judge did indicate that.
It's like every time you make your mortgage payment, you don't get a new note.
We don't get a new note, that is correct. And that was a analogy that I believe the state provided. But say, for example, you have a debt, a car debt, and you make payments toward that car debt, it should be subsequently reduced by each payment that's made, especially if you pay it in advance. Normally what happens with restitution, as the court knows, is restitution is ordered by the judge, then it's slowly paid down during the course of probation. In this particular case, prior to even entering a plea, the appellant agreed to pay restitution toward these victims an amount of $800 per month. Based on that unique scenario, in fact, in this particular case, I'd submit that the restitution liens should have been reduced in the corresponding amounts, and because she was not getting credit for the amount that she paid during the course of the case.
But if I understand your argument, every time she makes a payment, I would have to have her pay renewed.
No, that's absolutely not what I'm arguing, Judge Lewis. What I'm arguing is, if you have a scenario where restitution is ordered, a defendant pays that restitution while the case is pending, which is a very unique circumstance. And then there's a certain amount that's in the registry of the clerk that is dispersed upon conviction or sentence, that any corresponding restitution liens should be reduced by that amount because that amount has already been paid. It does not give a criminal defendant who pays restitution in advance under these circumstances. Say, for example, she paid $10,000 per victim, just a general amount. And then, the restitution lien is for the full amount, not taking into account what she'd previously paid. Well, what I'm not saying and what I'm not arguing to the court is every time a criminal defendant makes a restitution payment, there needs to be an amended lien filed. That's not what I'm saying. What I'm saying is if a criminal defendant agrees to restitution, pays a significant amount toward that restitution during the course of the case, that any subsequent issued restitution lien should take into account what was paid, which is not exactly what happened here. There's not exact case on point, however, it's a unique fact and circumstance. And the statute regarding criminal restitution specifically says that it should be offset for any amounts that are paid. That way someone doesn't double dip and get unjustly enriched. Turning to,
How was it handled how was restitution handled at sentencing? There was money owed.
correct.
Towards restitution. Was it converted to a lien? The fellow's in prison. Was it probation to follow to pay this restitution?
There was not, no, it was straight prison.
So what is it, what's the damage in terms of restitution being off by X, Y, or Z, you're not getting credit?
The damage is that it's civilly recoverable. If it's converted to a lien and someone owes property, like for example,
It's the amount,
it's the amount.
okay, which you,
It's the
we're
amount,
talking over $100,000 cumulatively.
correct, well over. And the problem with that is if there's real property that's not homesteaded, then of course these judgments.
Well, yeah, or if he hits the lottery, you know, that, I've heard that argument many times. And is that argument correctable in the future, should this happen? Where he has to pay something off, they could quibble over the amount owed?
Certainly, it could potentially be correctable in a civil action, but it makes much more sense for it to be correct before the lien is attached to a piece of property to avoid future litigation. You know, there, a lot of times, for example, in this particular case, there'll be a civil theft civil suit as well as a criminal, simultaneously pending
There was
criminal.
no civil suit in this case.
There was, yes, absolutely there was.
And what, did that result in an amount certain?
It resulted in an amount certain, and that was a large issue of contention during the case, and as part of the 3,800 was whether or not this person who obtained civil judgment was unjustly enriched by the criminal restitution, which is something
Down
that
to 4 minutes, I don't know if you want to keep going, or you want to save that?
I'd rather say that, Your Honor.
Save it.
Yes, sir.
I'll save it for you, sorry. Well, Mr. Kelhar?
Yes, good morning, Your Honors. William Shellhart, Office of the Attorney General, appearing on behalf of the FLE, the state of Florida. As to issue one, the state contends that this is purely a step 2 analysis of the Banks test. It is whether the judge abused his discretion in not granting a downward departure
Did the
sentence.
judge say in clear-cut terms, he's not a candidate for a downward departure?
Yes, Your Honor. So if you look at record page 321, and I'm quoting here, so I don't find that the evidence is sufficient. If it was sufficient, I would not be inclined to grant that as a basis of departure. He did. That's why it's a purely step 2 analysis. I understand counsel's argument about whether she was amenable or not, but quite honestly, that's an academic exercise that this court does not need to undertake. Irregardless of whether the court was correct or not with its step 1 analysis, whether she met that specific ground for downward departure.
Have jurisdiction to reverse and abuse of discretion on Kelly to give a downward departure.
That's correct, Your Honor. The only courts of the state that have reversed on this step 2 analysis is if the court misapprehends its ability to downward depart on a step 1 analysis, or has a general policy regarding defendants or types of crimes that it will not depart for, neither of which is present in this situation. And I would argue further that this court did not abuse its discretion. As this panel has pointed out, Ms. Walker was out on bond for these offenses. While she was out on bond, she committed the exact same type of offenses. So it's hard to imagine a scenario where this panel can say that no reasonable jurist of the state would not have granted her a downward departure, given the fact that she committed new law violations while out on bond.
Well, what about his restitution argument? Is there any merit to that?
As to issue 2, yes, I will concede that it is a unique factual scenario where you have a defendant who agrees to a restitution order as to each of the 3 victims in the first case prior to pleading guilty and being sentenced. The particular problem that this case presented is that at the time of sentencing, the monies had not been distributed yet. Yes, they have been collected. There was some evidence that it was record evidence, not actual evidence, that it was between $14,000 and $18,000 that was being held by the clerk's office.
Out of this cumulative sum.
Out of this cumulative sum. But you have 3 different victims with 3 different amounts of restitution owed to them. Yes, the restitution orders called for a specific $266.66 per month payment to each victim. However, when the money was distributed post-sentencing, what the clerk did was a pro rata basis. You had one victim who was out over $100,000. That was the bulk of the $168,000 that was owed in restitution. It appears that the clerk did the largest share to him, and then almost even shares to the 2 remaining victims. So what happened is with the 3800B, we can look back in history and say, hey, I understand that the court sentenced her at this time. At that time, the restitution had not been distributed. She had paid that amount, but since she has been sentenced, this amount has been paid, and we're asking this court in the 3800B post-sentencing to modify the restitution orders. Again, as this court has pointed out, there has not been demonstrated any harm as to this. This is a unique factual circumstance. The state will agree with that, given the nature of the 3 different victims, 3 different restitution amounts, how the restitution was collected and distributed. However, this court's holdings are never really limited to a specific case. The state fears that this will open Pandora's box as to what Judge LaRose pointed out. Anytime that a restitution amount is paid, that we would have to reopen the case below, petition, have a new restitution lien entered.
Basically, no one victim got more than 100% of what was owed.
No, Your Honor.
So if there's ever a time to correct a mistake, that could be done in the future, right? Because you've agreed to that.
Yeah, absolutely. And I think the trial court said as much, that if there's a problem with something, if you're not getting the credit for the amount that you've already paid, please come before me, and I'd be happy to remedy the situation that way. So we're talking about really theoretical harm for a restitution amount over 6 figures for a defendant who's going to be in prison for the next 10 years. I don't know the percentage of restitution that usually gets paid once a defendant is sentenced to a prison time versus a probationary sentence, but I can't imagine that it's being very high in the state. So we're really talking about theoretical potential, maybe harm in the future here. And again, I don't think that what the court did was wrong. There's been no case law cited by appellant. I certainly could not find any that addresses this specific unique factual scenario. And I would ask this court not to open Pandora's boxes this issue. Let the administration and the counting of the amount of restitution owed be handled in the circuit court or the county court.
We don't need a CPA to fix this.
I don't think that this court is the appropriate body
No.
to determine how restitution is administered or determined, especially given these unique factual scenarios. If the court has no further questions, I would rely on my brief for the remainder of my argument, and I would thank you for my time. Thank you.
Mr. Crawford, you've got 4 minutes left.
As it relates to ground one, again, I would submit that the trial court's findings were not supported by competent substantial evidence. You had an unrebutted testimony from a psychologist that the appellant in this case had a mental disease or defect, which was borderline personality disorder. There was a need for specialized treatment, which is the dialectical behavioral therapy, and she was amenable to that treatment. The defense proved this by the preponderance of the evidence. I understand that after the first part is done, the court still has discretion based on specific facts of the case. I would submit there was a abuse of discretion. As it relates to ground two, again, a unique factual circumstance. The court could limit its holding to the specific facts of this case. But the Ms. Walker agreed to restitution orders in advance of a criminal conviction, which is a very rare circumstance. She paid diligently over 18 months, a set amount for each one of the victims alleged in the case. Those amounts were ultimately paid. She should be entitled to a restitution lien that reflects the correct amounts rather than an inflated amount that didn't take into account the amounts that were properly paid. The future danger is that these liens could be executed on real personal property or any other assets that she has after her release, which do not reflect the correct amounts. I respectfully ask this court to reverse and remand for a new sentencing hearing or a correct order of restitution, unless there's any other questions from the other.
Gentlemen, thank you very much. Have a great day.
Thank you, Your Honors.
Call up the next case, which is R.J. Reynolds versus the estate of G.M. Baldwin. The case is combined. I don't know if there's any discussion we need. Attorneys will look up to divide time up between